next witness.
Good morning. My name is Mark Alpert. I'm a partner with Hart King and Coldren, and my law firm represents manufactured home park clients all over the state, has for 30 years. When this conversion law was passed or adopted, it was done so with the idea that ownership is a great idea. We want to facilitate ownership. And it's also undisputable that when it was passed, there was a concern over local governments interfering with that process for whatever reason, and the law is actually drafted to prevent that from happening. In 2002, a survey requirement was added to the law, but the legislative history from adoption is clear. When that survey requirement was added, that they were not intending to give a resident vote a veto power, the right to block a conversion. That's quite clear. Now, I understand that there's a lot of debate over the legislative history of this legislation, but what we're talking about here is a veto power, a right to take a right that is fundamentally with the owner of a property and give that right, subject that right to the residents. I think some legislative history going back a little bit further is actually relevant, about 230 years. When the framers of our Constitution adopted the Fifth Amendment, they were very concerned that what would happen is that voting majorities would vote to take away the property rights of minorities. That's exactly what this change in the law is proposing to do. It's saying a majority of folks who live as residents in this park can say no, can take away the right of the owner of that property to change the use of that property to a legal conforming use. Now, the United States Supreme Court in Yee versus Escondido said that the right of a property owner to stop renting, to get out of the rental business, is a part of the fundamental sticks in the bundle of rights you have as a property owner. It's fundamental. And yet, this law is proposing to essentially take away that right. Now, when I talk about property rights of the park owner, what I hear and what you've heard today is that the park owners aren't the only ones with property in this equation. And surely that's true. There are residents who live and own their mobile homes on these parks, and they do have property that should be protected. As Ms. Forbath pointed out, the current law already provides a great deal of protection. It provides the guaranteed right to rent. It provides a guaranteed option to purchase. It provides very, very strong rent protection to those residents who choose to continue to rent. Now, if we don't think that those property rights are sufficiently protected under the existing law, let's talk about that. Let's tweak that provision. What I find fundamentally impossible to understand is why we want to solve the problem of protecting that property by taking away the property rights of the park owner, when you can achieve that protection without doing that. If we haven't done that perfectly, let's work on doing that. So this solution, to me, is problematical because, number one, it violates fundamental property rights. Number two, there are better ways to solve the problem. Number three, you heard about the problem of litigation surrounding this kind of conversion. It's not going to solve that problem. You've heard this explanation that local governments will have all this great discretion. That is certainly true. Under the proposed change in the law, there's enormous discretion. But there's no direction as to how that discretion will be applied. And that is what leads to litigation. There will be more litigation because there will be no criteria under which these local governments exercise this broad discretion. There will be more litigation because fundamental property rights are being denied. If the concern that we're trying to take care of here is protecting the property of these homeowners, let's talk about doing it. Let's not try to achieve that by taking away the property rights of park owners.
I could ask you to bring your comments to a close.
Thank you for your time.